Welcome to the Dirty Verdict Podcast, where your host, trial lawyer Kyle Herbert and mediator Peter Taaffe break down Texas legal news, lawsuits, and verdicts. And now, here's Kyle and Peter.
All right, welcome back to another episode of the Dirty Verdict with mediator Peter Taaffe and
Kyle Herbert.
Trial lawyer Kyle Herbert.
We are broadcasting today through the miracle of the internet. Texas has been hit with a Arctic blast, and so Pete is co-locating to us live from. Are you in Westlake, Texas, Austin, Texas? Pete, where are you today?
I am in the Westlake area of Austin, Texas.
You run into McConaughey lately?
No, I'm kind of like Sarah Palin in Russia. I can see him from my doorstep or see his house.
Is he wearing, when it gets real cold, does he wear a shirt or no? What's the story on that?
I seriously doubt that. And it's definitely not that. I mean, it's only 32, so it's got a while to go before shirts come off. Shirts go on.
Yeah. That makes good sense. We have the same rule in my house.
Yeah.
We are a lot of midriff kind of family. So that's good. A lot of T-tops. All right, Pete. Let's jump into our first interesting case. We've got a lot of really interesting stuff today to talk about. Tell me about this first case regarding a former Chicago Bear. I'm going to call this the Bald Bear case.
All right. Brian Urlacher, who any sports fan will remember him from about 10 years ago. He was the guy, linebacker, looked like a Chicago Bears linebacker.
Mm-hmm.
And has since encountered with some people, not obviously you, Kyle, but some men of a certain age start to lose their hair.
Not me. I've got a majestic.
No, you've got a
majestic
even
voice.
Even on Zoom, I could tell, even if I didn't know of your fabulous hair. But some of us are dealing with that, and I guess Mr. Urlacher sought treatment for that in Houston at the Houston Hair Transplant Center, which totally fine. I'm sure it did a good job. And obviously the Houston Hair Transplant Center thought so. So they told his story on some of, I'm sure, their social media posts. I mean, who doesn't want to have a celebrity endorser say that they've actually used your product and it worked?
So I got a couple of real quick preliminary question. When he played for the Bears, like in my mind, I have a vision of him with like steam rising off his bald pate. Am I thinking of the right guy?
Yeah, I think he wore it well. Like he kind of embraced the ball back in the day, but
sure,
as a football player, and now he's out and I guess doesn't need to be so tough looking. So that's fine. So he according to the Houston Hair Transplant Center, he received an FUE procedure. And we try to bring relevant news to people and things that you can talk about with your friends. FUE means follicular unit extraction.
Wow. That's a mouthful.
And so he had the few, as we call it in the biz, and they wanted to talk about it, and he wasn't having it. So he has filed suit in Cook County, which is Chicago, Illinois. He's filed a lawsuit seeking at least $50,000, court costs, attorney's fees, and punitive damages.
So I got a couple of questions here. One, the dude must have millions and millions of dollars. So I've got to imagine like they must have sent some kind of cease and desist letter and they said no, because otherwise, I mean, hiring a lawyer to go after $50,000 plus attorney's fees. I mean, that is a lot of work that's a lot of squeeze for not a lot of juice, if you know what I'm saying.
Yeah. And it's not going to be cheap for the Houston-based company to go hire a lawyer up in Chicago to defend it. So I think maybe what could be behind it is just drawing a line, making sure setting an example to put it to bed.
So
Um,
there is an interesting case about this. I remember in law school, and I believe it's Kareem Abdul-Jabbar, I believe, versus Oldsmobile, where Oldsmobile had used some footage, I believe, of Kareem from the NCAA championships when he was at UCLA, and they put that in the background of some sort of a car commercial or a car show, and he sued them. And if I recall correctly, that was basically the seminal name, image, likeness, privacy tort development of that case law. So I would imagine, unless Mr. Urlacher has signed a contract with these folks, which maybe they have, and that was kind of my next question. You might not know, um, the the lawsuit alleges that they have footage of him basically giving a promotional speech saying, this follicle extraction process made my head beautiful and amazing. And I mean, he had to know as he was saying those words that it might be used for something. Rarely do I have a medical procedure done where I, expound on the greatness of the doctor. I'm curious if he thought he was going to get paid for this someday or not. But that was curious to me that he apparently sat down, talks about all the great things that this procedure did for him, but now he doesn't want him to use it. So I wonder if it's just a dispute over compensation or something, but who knows? You got any ideas, Pete?
no, you're right. According to the story, it's hard to tell, but it seems that the author is saying that they've got billboards featuring his likeness all over the city.
Wow.
In Chicago. So yeah, it is a little bizarre. We'll need to dig in deeper into that. It's a little harder to find court filings in Chicago than it is in Houston, but we'll do some more investigation on this and check it out. It could be a deal that there was an agreement that went south.
Pete, what is the travel stipend situation for the Dirty Verdict? Do we have that in the budget to get me up to Chicago? Because there's a lot of things I love about that town, not least of which is hot dogs and deep dish pizza. And if I need to make that sacrifice for the Dirty Verdict, I want you to know I'll do that.
Yeah, we should probably think about doing that when it's not January or February.
Yeah, absolutely not.
Maybe we'll go for the first pretrial conference in like June. Go check it out.
That's a great idea. All right, moving right along. Next story arises out of your hometown, Pete. Tell us about what's going on in Rainey Street in Austin, Texas.
All right, a lot of people know, whether they're from Austin or not, that Rainey Street was a residential street of small, 1950s era houses that is right by downtown.
And now it's
right by
blowing up.
I-35. And beginning actually with a high school classmate of mine who opened a bar down there maybe 20 years ago.
Oh, really?
After that was the first one, and then it is now blown up to where it is all restaurants and bars. Most have been houses that have been repurposed as bars or restaurants, and there's still a handful of houses that have not been redeveloped. But otherwise, there's the Van Zandt Hotel. There's multiple apartment high rises. There are construction cranes there all the time. It is amazing how they can put that much stuff onto one, or maybe 3 blocks worth of space, but they're doing it.
So Rainey Street now is like what 6th Street was 30 years ago.
Yeah, Rainey Street it's not a place necessarily that you see a lot of people our age there. Although,
but do you mean the folks there are a little bit less vintage than you and me, Pete?
A little bit. There's still some. I mean, the hipper ones. You do great there. I stick out like a sore thumb, I would say.
Pete, you're pretty hip.
Yeah, but no, it's kind of I would say it's a place. The kids that are out of college that don't want to go to college bars, they want to go to, adult type bars. It's kind of that age, at least from my amateur view. And it's pretty high end crowd. But unfortunately, according to one recent lawsuit against a Rainy Street restaurant called Cantina 512, which I've never been to. And to be clear, don't own anything in it or know anyone who has any involvement in it. According to the lawsuit, a few potential patrons tried to come in and they had dreadlocks and came to learn that this bar has a policy of no dreadlocks allowed.
No dreadlocks.
No dreadlocks, which...
What in the Ricky Williams are they talking about?
So a federal civil rights lawsuit was filed saying that they were deprived of their civil rights. I don't believe there's a constitutional right to dreadlocks, or really, to be fair, any type of hair styles.
Well, the Supreme Court. Well, the Supreme Court is really veered towards, what do they call now, like their religious historical tradition interpretation of the law. And so, I mean, Rastafarians have been here at least since who's the singer? Greg
Bob Marley?
Well, Bob Marley, of course. Who's the guy? Are you gonna go my way? What's his name?
Why don't you sing a little bit more, and we'll probably figure it out.
Oh man, we definitely should not do that. Why can't I think of this guy's name? That's crazy. The brain's really going on me. It's all my dreadlocks taking all the juice out of my brain. So what are they saying, that because the restaurant is a common carrier, that they can't discriminate against people's hair?
No, that's what I was leading into about there not being a constitutional right. There's obviously not in the Constitution. Even I know that. However, what the allegation is, it is a pretext for racial discrimination.
Sure.
And
racial discrimination in the operation of restaurants and cabs and trains and planes. That is in fact illegal, right?
Yes, that is. And so the bar owner has denied that there's any such policy and never had a policy like that and never will.
Are they saying
that's
some
why
bouncer?
No, right. That's why you do a little something called discovery to find out where this idea came. It could have been, just some random bouncer who didn't study his constitutional law as closely as we do. Didn't know, but that's the allegation. That is a relatively new case. It's interesting.
Are they talking? So this is a point of order here, Pete. Are they talking about the kind of dreadlocks that African-American folks have? Or are they talking about the kind of dreadlocks that homeless people have because they don't wash their hair? Or do you know?
I don't know the answer to that. I'm guessing the person that set out the no dreadlocks policy probably didn't do a whole lot of thought on the scope. There probably wasn't a lot of drafting involved. Anyhow, we'll play it. We'll keep a little bit of an eye on that one. That one should.
Lenny Kravitz, sir. Lenny Kravitz.
Yeah, that's something that should get worked out. Don't have the dreadlocks policy, hard stop, and can you get out of paying any additional damages on top of that?
Before we get too far away from the club food beverage industry, we've got another case. This one, I got to tell you, hits close to home. I have never been a fan of Fireball. It tastes like cough syrup to me. But this past fall, I was actually in Kansas with you, Peter, to watch a football game, and someone prepared for me a hot cocoa with chocolate and marshmallows and all the good stuff. And then they put a shot or two, maybe 6 or 7 shots of Fireball into it. And whoo, Peter, I got to tell you, that made the beverage. And now, I come to find out, I have been hoodwinked. I have been duped. It sure seems like the Fireball folks are pulling a fast one. Tell me about this case.
Class action lawsuit back to Cook County, Illinois, where we were just in the Erlacher case. There's been a suit filed it's actually in the United States District Court for the Northern District of Illinois, which is a federal court. They say that Fireball is deceiving its customers by claiming that it contains whiskey when it does not. That it's actually, according to them, It's malt based and wine based. So let me dig in a little bit. This I actually noticed this recently when I was in the like a 7-Eleven. They have
Right.
those. They have those in Fireballs in the same little small containers that used to be airplane. We call them airplane liquor bottles. And I thought, I know you can't buy hard liquor in a 7-Eleven or a convenience store, or really anywhere outside of a liquor store.
Right.
So I looked at the time to see what was up, and I saw that it was disclosed on there that it was not. It was whatever, some malt based or however they make those kind of whatever these all these spritzers and seltzers and things like that. Same kind of thing.
That's weird, because you're a White Claw man, as I understand it. So I wouldn't have. I'm surprised that you would have delved so deeply into the Fireball.
But I'm like you in that,
You're just
particularly at
curious.
a game, like the Kansas game where it was like 15 degrees. There was nothing that warmed you up better than a whiskey Fireball. I don't think I've ever had one with the malt or whatever it is.
Tell me, what are the damages here? Because I know my damages, and it hurts my heart. And that's it. It hurts my heart when I drink it, but now it hurts my heart to know that I've been deceived by Fireball. The lady who filed this suit in Chicago, I mean, I'm all for truth in advertising, but how do you quantify the unquantifiable, which is a broken heart over Fireball?
Well, as you know, most of these things settle with some amount of money being paid to the lawyers and then some type of coupon. I know that judges aren't real big on coupons anymore. So that will be a challenge, that even if the owners of Fireball want to settle it, how can they do it in a way? A lot of times it's actually can be a good business development tool, because maybe they give out coupons to Fireball and now people go, instead of just buying one, because why buy one when you can buy 10? And then they end up selling 9 and giving away one free one.
I am wondering if these lawyers are just hoping to get paid in Fireball.
That could work as well. That would be a first of its kind.
I'm willing to serve as an expert witness in this matter if either side is listening, and I would be more than pleased to have my fees paid in Fireball.
Excellent. Yeah. So just so I understand, Kyle, the one you had in Kansas, that was a legit whiskey Fireball. I think.
Well, is that the point? There's 2 different kinds of Fireball?
Yes. Yes.
Insanity. Yeah, I mean, duplicitous. It's a travesty. It's a mockery. It's a Travisham mockery. Now I understand what they're doing here. Yeah, I think that all Fireball should be whiskey Fireball. What did I have? I don't know. I couldn't tell you. It tasted like cinnamon cough syrup. So who knows?
Yeah, I think there's something like Jack and Coke that they sell in convenience stores, which is not Jack. And I'm sure it just is some type of liqueur that is malt or wine based that made it taste like a Jack and Coke, a bourbon and Coke. But so I don't know. I think that will be that's coming up. This same firm has sued. I think it's the same firm or maybe the same plaintiff. The law firm, let's see, has filed 400 suits of this similar type since 21, according to NPR, including alleging that Frito-Lay doesn't use enough real lime juice in its hint of lime Tostitos. Falsely advertised the strawberry content in the frosted strawberry Pop-Tarts. And then most recently filed suit against Velveeta, claiming its shells and cheese
aren't made of real shells.
No,
those aren't crustaceans at all.
No, they take long. The allegation is they take longer than 3.5 minutes to make.
The Big Mac is neither big nor a Mac. Discuss. This is crazy. Peter, I want,
like I said, there's 400 such suits. So those are just probably 3 grab bag, but we could
you and
probably,
we got to get on. We got to submit an application. This is the law firm one of us needs to work at.
yeah.
I mean, or become full-time professional experts so we can give testimony in cases like this. I tried the hint of lime Tostitos. I could detect nary a hint, less than a scintilla of a hint, Judge. I mean, this is going to be a real growth industry for both of us.
Yeah, there's just looking into the historical context of the word hint, what that means.
Mm-hmm.
Is it a scintilla? And what is a scintilla?
Whew. I mean, these are legal standards that probably only Dr. Pepper knows, which is another issue. I don't think he actually went to medical school.
That's true. And I think probably this firm is looking into that as we speak.
I'd like
But
to see his
that'll cause a problem.
I'd like to see the credentials, sir. I'd like to see your medical license to practice soda pop.
Yeah.
Dr. Pepper.
All right. Well, turning to another favorite of mine, probably yours, a lot of people actually, Buc-ee's.
Yeah, back to Buc-ee's. Let's do this.
Buc-ee's is a staple really for anyone,
any weary traveler.
Around Texas in particular, and even they've got them in Alabama, other states now. But they are not immune to a lawsuit involving slips and falls, as we've discussed a couple times with one of our other favorite institutions, Total Wine and More, particularly the one on Holcomb by your house. Buc-ee's is not immune from that either. So, according to a lawsuit, the Buc-ee's in Lake Jackson, someone slipped on accumulated ice that spilled out of an ice machine. And so he believes that Buc-ee's is responsible for failing to detect the condition, not taking action to warn, failed to inspect. So
I'll say this.
We've covered these a couple times. Go ahead.
Whenever I'm driving and I need a whole wall of crucifixes or some fudge and some gasoline, there's only one place I'm stopping, and that's Buc-ee's.
Well, and jerky, they
do well on the jerky, no doubt about that. That is pretty impressive. Who is the lawyer that filed this Buc-ee's case?
This is Kenneth Baird.
Kenneth Richard Baird.
Yeah.
I know Mr. Baird. Have you met Kenny?
I do. He actually he does a lot of premises cases. I'd say he's extremely knowledgeable on these types of this area of law. There's a lot of lawyers, as you know, that will shy away from these cases because of the challenges we've discussed. But to credit Mr. Baird, he handles them and is we don't call people experts and because we just don't have that certification. But he is extremely knowledgeable on premises liability claims.
His office was next to mine for a couple of years. He's a very fine lawyer. Anything interesting about this other than just, how much ice I'm wondering was spilling out of that Buc-ee's. I'm also surprised because it seems like they've usually got like an army of people with like squeegees and mops, but who knows? Maybe Buc-ee's dropped the ball on this one.
Well, one, they have really good ice, and they also, there's a place that a lot of little kids are in. So I could see like a little kid just going haywire, getting ice out of there. The other thing is on some like Saturdays and Sundays, that place is extremely crowded. Yeah. It is in the lines, and that's why it shows how popular it is, but that can happen. So we're not making any comments on the merits of anything. We're just using it as an opportunity to talk about the law for our people that don't do it every day and kind of talk about that issue. And also to say that even loved institutions can face the lawsuit.
Well, maybe we should reach out to Mr. Baird and see if he wants to fill us in. And that seems like an interesting case, a typical case. We see that a lot. I've had spilled ice cases, spilled fluid cases, spilled milk cases. But that might be an interesting one to follow up on. Tell me about, so this next one, I used to live just down the street from the next establishment. Tell me about this case.
You talking about the turkey leg hut?
I'm talking about the turkey leg hut, sir. Tell me about the turkey legs.
Well, Turkey Leg Hut was sued by one of their suppliers of turkey legs, which is U.S. Foods, which is one of the largest, if not the largest, food distributor in the country.
Let me put you on pause real quick. So for people not in Houston, Turkey Leg Hut is a restaurant, relatively new restaurant, a few years old. It's kind of in the museum district along South 288, just south of downtown. And I have never eaten there, much to my embarrassment, because I have made plans to go there 4 or 5 times, and I walk by, and there, no joke, will be 400 people in line waiting to get turkey legs, and they're stuffed with all kinds of. You can get a turkey leg with brisket, a turkey leg with more turkey in it. You can get a turkey leg filled with boudin. By all accounts, just fantastic food. But sounds like they're in some financial problems. What's going on?
Well, you're right. I had the same experience with them, and I would love to go there, but yeah, every time I've driven by or intended to, I just don't have the time to wait. But they're obviously doing extremely well. But according to U.S. Foods lawsuit, they owe them. Turkey Leg owes U.S. Foods $1,288,000.
That is a lot of turkey.
Which dates back to invoices in September of 2020. So we know what was going on. Then COVID may have gotten a hold of them.
Well, that is not true. Because
They still rocking back then.
Man, I lived right by there during COVID, and the place was a hot zone. I don't think they shut down for one day. And I'm not saying that's good or bad, but you would go by there on any day that they were open, and that place never skipped a beat. Completely, totally packed. They might have shut down. I think there might have been a period where our county judge, Lena Hidalgo, required restaurants to shut down or face fines, and they might have shut down for that period. But there is no way they were impacted by COVID, because they were blowing and going that whole time. But could you tell me again how much U.S. Foods alleges they're owed?
$1,288,000 in change. A lot of it, according to the agreement, there was a 1.5 interest per month on past due invoices, so that'll add up quick. But Turkey Leg is fighting back. They've released a statement saying Turkey Leg Hut was not aware of a pending lawsuit until we were contacted by the media Thursday afternoon. From what we can see, this is not adding up and cannot comment further on the pending litigation. The math is not mathin'.
Could you, so that might be a term of art I've never heard in a legal context. Could you repeat that quote to me?
The math is not mathin'. So I suspect they may say, well, we think we owe you something, but where you've come up with all this other stuff is ridiculous.
Well, again, I would love to have Turkey Leg Hut maybe deliver some turkey here, and we could revisit this and really talk some turkey. But before we go any further, I'm looking at Turkey Leg Hut's menu, and I'm trying to figure out how many turkey legs is $1.2 million. So let's just go with, oh my gosh, these turkey legs are $40. Oh wow, that's a whole meal. All right, the famous leg, their most popular dish, that is going to be a $14.99 slow smoked turkey leg prepared with a secret ingredients and seasoning, and it literally falls off the bone. Pete, what is you said a 1.2 million?
Mm-hmm.
All right, we're not even going to worry about the interest. What's 1.2 million divided by $15? Quick math. You're like Rain Man. You're kind of an idiot savant. At least half of those.
Yeah, especially when my calculator comes up on my phone.
That's 80,000 turkey legs, Pete.
Yeah. So, is the $15 turkey leg? Is you just get the leg, and is it stuffed, or you get a side?
That is a plain leg with secret ingredient and seasoning. And let me hold on. And to go back to the exact term of art here, I'm going to read it exactly as it appears in the menu. Famous leg, slow smoked turkey leg prepared with our secret ingredient and seasoning. I don't know what the secret ingredient is, but it looks good. Now, I do want to warn you, consumers out there, before you just start showing up craving a $15 turkey leg. That is your entry level turkey leg kicker, because boy, do the prices go up from there. In fact, the stuffed leg is $26.99. The Hennessy leg is $21. I think that is a leg marinated in Hennessy. You got your leg Florentine coming in at $35. And it looks like the creme de la creme with tax, title, and license would be the seafood gumbo stuffed turkey leg, which is rolling in at $36.99. Now, that's a lot of turkey.
We'll definitely have to go. Is there an option to take out so you have to wait in line, or would you have to like try to pay someone to wait in line for you?
You know what? I bet we could Uber Eats that or send some member of our production staff. Josh, Chase, you think maybe for the next one I can get one of you guys to pick me up some turkey? They're nodding in agreement, so that seems like a good sign. Well, I'll let you guys throw in. I'll buy for one of you guys to split the $14, just a plain turkey leg. You guys can split that, but I'm gonna need the seafood gumbo turkey leg. Probably. What do you need? 3 of those, Pete?
I wanted the Hennessy also, mix in the Hennessy.
All right, so we're talking that's probably $150 worth of turkey. I'm gonna have
good. We're doing our part.
Yeah, to pay off this debt to U.S. Foods.
Yeah,
we're gonna need to really increase the marketing budget for the Dirty Verdict. Let's take a look at this last case, and we do like to have a fair amount of fun when we can on the Dirty Verdict. The law doesn't need to all be doom and gloom, but I'm going to refrain from making light of this next case because it is pretty bad. And the plaintiffs, if what they allege is accurate, have really suffered significantly. Tell us about this next case.
Sure. According to the Abraham Watkins law firm, they have filed a lawsuit, which I've reviewed, in which they claim they represent 13 women who claim to have contracted herpes simplex 1 by drinking out of water bottles, standard water bottles that everyone who works in an office will use to stay hydrated. They claim that a maintenance worker, or he's named in the lawsuit, he's named in the press, but we'll dispense with that. He was a janitor, actually, was allegedly placing his private part into these bottles at night when he would go clean, and in some cases, or maybe all cases, urinated in those bottles. The first one, this first lawsuit was filed several months ago. They've since filed a second one, and then they've amended their petition on their first one to flesh out some more allegations and details. Everyone worked in the same building, according to them. He was the janitor for that building. They claim that they put the landlord on notice. One had a suspicion that something was up, set up a private camera, and caught him, according to her. And she showed the video to the media. Told the landlord, the building management company, and that she said she's going to go tell the other tenants, so they're aware that it's what's happening. And according to the plaintiffs, the building management company didn't do anything for 6 days. Meanwhile, he was still up to his bad acts. So that's just 13. The lawyer believes that there's probably more out there. He's probably right. And the management company's only response is, we immediately cooperated with the police department in this matter as soon as we were made aware of the potential issue. They were advised by the police the management company is advised not to alert or approach the alleged perpetrator so he could be arrested. He was arrested when he returned to the building. So answers have been filed in that first case. The second one was recently filed, so the due date for the defendants to respond has not come up yet. Kyle, do you have any thoughts that you can share?
They've got some lawyers that have answered in here, which is interesting. I know a lot of the folks on these pleadings. Well, number one, what this guy did is absolutely disgusting, and I have probably more words to say about that I'll keep to myself. What a dirtbag. I see two interesting legal issues here. One is causation. I mean, the case for the plaintiffs gets better if they can show that the plaintiff's employer knew or should have known that this kind of bad stuff was going to go on, right? And so I'm wondering, is there any way to prove when you contracted this disease, or will will the jury just assume that it happened in that 6-day period, after the hospital or the facility and the management company were put on notice? What do you think of that?
Yeah, that's well, one, just the causation link between, apparently he has this STD as well, and apparently they've tested the bottle and it can tie his, I guess, urine is in some of these bottles. Now, which, did everyone preserve every bottle? No, that's going to be hard. A lot of this is typically done, as you know, by expert work. The plaintiff's firm, is one of the top firms in the city. They're well financed, and they have certainly the ability to retain the best experts to make the case and draw all the causal links together. But that will be an interesting to see how they actually do that.
Yeah. So my next point, which maybe I put the cart before the horse, I was just going to point out that the defense for all of the defendants, except for the guy that actually did this, so first of all, the guy that did this, he's got nothing, right? Like he's got no assets. He's got no insurance policy. So
Right.
these lawyers are suing the building owner, the maintenance company, everybody that's got insurance, to try and ferret out who's responsible and who should pay for it. And so every lawyer probably sees this right away, but the issue is going to be, how do you tie the criminal bad act of one employee who's, they're going to argue, not within the course and scope of his business, to the company? And the company is going to argue, look, we can't be there for every second. We certainly didn't tell him to do these bad acts. He's acting in an ultra vires manner outside the scope of his employment. And so that's how they're going to try and get around that. But boy, I never thought I'd have to say this. I mean, my biggest complaint is my janitorial staff drags trash bags across the floor and it leaves little stains. But I guess, leave no open food or beverage containers on your desk, because I guess you never know who might be out there lurking to do something just totally weird. And I gotta wonder if this guy's like mentally ill, because who would do something like that? And I don't want to disparage the guy. Maybe he's not mentally ill, but man, that is just so far beyond the pale of normal behavior. It's just kind of gross, which makes me also wonder, like, what's in that guy's employee file? Like,
Yeah.
right?
So your point is on foreseeability, meaning a defendant has to have reason to have foreseen that something like this could happen. And one way to do that is to show that either they should have, to do a background check on him and find out what he's been accused of in the past, and then find out, did they do that, or should they have done that, found that before they gave him unfettered access to people's private effects, really a janitor.
You've seen this in your practices. I have in mine. When somebody does something totally off the rails, I had a case a few years ago where a employee of a car company, just a company that sells cars, and a reputable one, a big one, would run this scam where he would let people take cars home for the weekend and ask for, a $2,000 down payment, get the money back if you don't want to keep the car over the weekend. And then he would pocket the cash. And then he would accuse the people that took the car of taking it without permission and not returning it. And then he would report them to the police and do all kinds of like crazy stuff to try and keep their money. And he targeted lower income folks who really, couldn't defend themselves. And he would do that for a couple of weeks, and then it would get kind of hairy. So he would quit and go do another job. the defendant in that case, the car company, tried to argue this was a random criminal act. Who could possibly know that this was going to happen? Well, if you ran a criminal background check on him, you would have seen that he had been convicted of the exact same scheme multiple times, that he was a fraud feeser, that he had been convicted of theft by check 25 times. And so, we kind of fought that in my case. I actually brought a case for basically wrongful imprisonment and malicious prosecution, and did pretty well on it. Because they tried to argue quite unsuccessfully that there was no way that this was foreseeable. And even Googling the guy's name would reveal how incredibly foreseeable it was. And that'll be, this quite honestly will be a real interesting case to follow. Maybe we can get some of these lawyers to come up and talk to us about it.
Yeah, that'd be good. The two other takeaways I have are, I always thought about this, particularly as lawyers, is you leave the office at whatever time. And I was a night owl when I was in practice. I liked having that quiet time where you could think and write and research and all that. So I'd be up there a lot as the only one, and the staff would come through, and they're all very nice, and I'm not disparaging them. But I was just thinking, people will just leave valuables on their desk in their office. People have artwork and different things like that are worth, up to hundreds of thousands of dollars around. And not to mention, if you're a lawyer, we all have passwords and things for our computer,
Sure.
But maybe someone doesn't. Maybe, someone just disabled that and said, I'm not doing that. And someone could come in and heck, it could just not even be a real maintenance person. It could be just someone that put on a shirt, and I don't know what they're doing. So I do think, you always hope with lawsuits when horrible things like this happen that they will, aside from compensating people that, if it's determined that there's fault, that there'll be some changes made in society and in management and operation of businesses that will protect. So,
my firm we have had security problems in 20 years, once or twice, and I am convinced that whenever this stuff happens, it's not to disparage the hardworking folks that do, this kind of nighttime work for janitorial staffs, but I wonder how often burglaries are an inside job. We had just moved into a new building. This was many years ago, not in the building I'm currently in, but they had reconfigured the arrangement of the walls. And where you previously could not gain access to our set of offices because the walls went all the way to the actual concrete decking above, they had reconfigured it when we moved in. And it was a big dispute between us and the landlord because they were supposed to build it to the upper deck and they didn't. And we went around and around with them. But you could not know that unless you were familiar with the building. And we had been there a couple of months, and somebody came in, got in through the crawl space above our exterior wall, which was a very small area. He popped out she popped out two ceiling tiles and walked off with thousands of dollars of laptop computers and all kinds of other stuff. But there's no way anybody would know to go to that spot or look for it unless they were intimately aware of the new construction and how the floors were laid out. So I was convinced, of course, the building, we can't find the tapes. The security guard was taking a nap, whatever excuses they had. But I was convinced that they somehow miraculously lost the tapes because I was convinced it was an inside job. And I'd be curious to see if this effectuates any change because, boy, what a terrible thing to have happen.
Yeah. And then just back to the kind of nuts and bolts of practicing. The other issue is in these types of cases, and this would be a more common scenario would be someone who is attacked or injured or killed in their apartment complex
or their office building or any place with security.
Yeah, and the plaintiff sues the premises owner of the apartment complex.
Mm-hmm.
Well, aside from the foreseeability thing that we talked about before, you also have the legal issue for the plaintiff is that we have a law called the responsible third party law,
mm-hmm.
where the defendant can say,
wasn't me, somebody else.
Yeah. So that's always a risk in these from the plaintiff side. However, there's plenty of huge verdicts and settlements that come even when there is, where there's been a serious assault at an apartment complex, where that has been attempted. So it's a little more inside law stuff, but that's always out there, and that's a concern that plaintiffs' lawyers need to address or be cognizant of any case like that.
Well, Peter, thank you for your time tonight. This was informative and interesting, and several of these I really do want to follow up on. Let's put a bookmark in some of these and track them back down here in a couple of weeks. Have a great weekend. Stay warm, stay dry, stay off the streets there in Austin. Hopefully the Arctic blast will end soon, and we can all go back to our lives as normal.
Sounds good. Thanks, Kyle.
Have a great night, Pete.
You too.
Thanks for joining us this week at the Dirty Verdict Podcast. For links to some of the stories discussed today, please visit our website, www.dirtyverdict.com. If you have obtained a recent verdict and want us to discuss it, please email details on the verdict to us. Also, please follow us wherever you get your podcast.